Kelly, for joining us for today's webinar on preventing workplace harassment presented by the CSC Pool and CPS HR. My name is Mackenzie Keller with the CSC Pool, and I am joined by Jennifer Houston, a Senior Human Resources Consultant with CPS HR. For those of you who aren't familiar, CPS HR is a client-centered HR and management consulting firm that is celebrating its 40th year as a self-supporting public agency. CPS HR is a trusted partner for HR consulting and comprehensive HR solutions that drive advanced organizational performance. Our presenter today is Jennifer Houston. She has 33 years of experience in human resources management, leadership, and professional business experience. Ms. Houston has earned multiple certifications, including employment law certification and certified mediator through the certified mediator through the Employers Council, among several others. Today's presentation will focus on how to promote a respectful workplace, how to prevent sexual harassment, abusive contact, and retaliation, and what an employee's role is in the complaint process. If you have any questions throughout the webinar, you can put them in the chat so that our presenters can see them, and we will have time for you to ask questions at the end. Without further ado, Jennifer, I'm ready to turn it over to you.
Wonderful. Thank you so much, Mackenzie, and thank you all for inviting me here this morning. I'm happy to share this next hour with you discussing sexual harassment. Not always, the most exciting or best topic in the world, but one that's really necessary for employers, especially in this day and age. As I feel like laws are changing rapidly. It used to be that there was one sort of governing law over harassment and discrimination, which now the states all have a variety of different laws, especially Colorado, which we'll talk about here as well. So let's go ahead and dive in. So our topic today, some of the things that we're going to discuss are the federal and state laws governing sexual harassment. We will talk about Colorado's 2023 Power Law, and we'll learn the proper procedures for reporting sexual harassment. We'll talk about the employer's obligations once a sexual harassment complaint has been received, and then identify waste and abusive conduct in the workplace overall. So federal law, let's kind of just cover the overarching umbrella here. So we have the Equal Employment Opportunity Commission, who defines that discrimination occurs when you are being treated differently than others or are harassed due to a protected class. And they regulate the Title VII of the Civil Rights Act of 1964, which is where the laws were defined regarding harassment and discrimination. So Title VII makes it unlawful for an employer to fail or refuse to hire or to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such an individual's sex. Now, this would also say, race, gender, religion, disability, etc., but we are specifically focusing on the sexual harassment today. It also states that to limit, segregate, or classify his employees or applicants for employment in any way which would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee because of such an individual's sex is defined as sexual harassment or discrimination. So again, this law was written in 1964 and specifically states his when it refers to an employee. So maybe one more thing that could be updated is the language there as well, but that is still our governing law for sexual harassment, along with state law. So about federal law, so the protections under the federal law, Title VII, include race, color, national origin, sex, pregnancy, religion, age, disability, and genetic information. And while it's not specifically stated in Title VII yet, the EEOC and the courts have said that gender identity and or sexual orientation are also protected classes. So even though it's not stated in the law, the courts have defined that those are protected classes as well from gender discrimination or sexual orientation discrimination or harassment. So Colorado law has all of the same protections as the federal law, but it also includes creed, gender identity, gender expression, ancestry, marital status, and marriage to a coworker in a limited aspect. And we'll talk about some of those as we go forward. But you'll find today is you'll see that there are differences between Colorado law and federal law. And one of the things to remember is it's important to note that the law that takes precedence is the law that's most generous in its protections. So, Colorado law is actually more generous in its protections than federal law. And again, we'll note that in a new law that we have that we'll talk about here momentarily. But so remember that when you're reviewing any of these things, Colorado law is more generous. So this is the one that would take precedence when you're evaluating any claims or concerns of discrimination or harassment. So there are two different types of discrimination in general that the EEOC defines. One is job status discrimination, and that's discrimination with regard to hiring, firing, compensation, promotions, and other terms and conditions of employment. And then there's hostile environment discrimination, which is unwelcome conduct that is based on an employee's membership in a protected class. And that defines that conduct is unlawful when enduring the offensive conduct becomes a condition of continued employment, or the conduct is severe or pervasive enough to create a hostile environment that a reasonable person would consider intimidating, hostile, or abusive. So we'll kind of dive into a little bit more of these two, job status discrimination and hostile environment discrimination. However, when you look at the two of these, just as kind of out of curiosity, and if you want to throw it in the chat, you can. Which do you think is the most common type of discrimination claim? Job status discrimination or hostile environment discrimination? So if you want to put that in the chat, that would be great. But like I said, we'll kind of define and talk about these more as we go along. Yep. So hostile environment. Yep. You're absolutely right. Good job. You guys are like on top of it this morning. So yeah, hostile environment is the most common type of harassment or discrimination complaint that we get. And we'll kind of talk about why that is occurring as we go forward too. So some stereotypes versus some realities. So common stereotypes are that the male is always the harasser, the female is the victim. It's generally in a situation where the supervisor is harassing the subordinate, that sexual harassment is motivated by sexual desire, and it has sexual content or context to it. However, the reality, and this has changed quite a bit over time, is that women can be harassers, men can be victims. There is peer-on-peer harassment. It's actually, and that's tending to be more common than supervisor against subordinate. There is same-sex sexual harassment, and we're finding that sexual harassment can be motivated by animus versus sexual desire. It's not always about sexual motivation. And it does not even need to contain sexual content to be considered harassment or discrimination. So let's talk about some legal obligations. From an employer's perspective, you are obligated to take all reasonable steps to prevent and deter harassment. So these could be things like making sure that you have a great solid harassment, anti-harassment policy in place. Excuse me. You are training your team on anti-harassment measures. You are creating a culture that says you will not tolerate harassment or discrimination. Those are great, reasonable steps to prevent and deter harassment. If harassment does occur, you're obligated to stop that harassment. You're obligated to investigate claims of harassment and protect employees who complain about harassment. Protect them from retaliation and also protect them from that behavior occurring again. So it is important to know that employees have some opportunities to them if they make claims of harassment as well. And the employees can have individual harassers subject to legal claims. So again, in the second bullet point there, victims may file a lawsuit against individuals. In Colorado, It is not, sexual harassment is not a crime unless it involves battery or sexual assault. However, an employee can name their individual harasser in the lawsuit as well. So generally, employees mostly name the company, the agency, the employer, etc., versus the individual harassers, however that can occur. And I feel like this is an important point for supervisors, particularly to be aware of, because supervisors can be named if they were aware of the behavior and didn't stop it, if they were part of the behavior, etc. But it is important to know that that is something that can occur, that it wouldn't necessarily just be against the employer or the agency overall. So every worker has a right to be free from unlawful harassment. This includes employees, job applicants, unpaid interns, independent contractors, and vendors. This is a very important thing in protecting your work environment, making sure that your employees are given these rights to be free from harassment. And so maybe if they even have an issue with a customer that calls or somebody that comes in to the office or something, it is your job as the employer to make sure that your employees have a work environment that is safe and free from harassment overall. So there might be issues that you would have to attend to that actually don't involve other coworkers. They might be from somebody from the outside. And again, that is part of your obligation as an employer to make sure that you're protecting your employees there. Okay, let's dive into hostile environment discrimination. And we are going to spend more time on that than job status discrimination because, as you all noted, that is the most common type of discrimination complaints that go that happen in the world. So again, it's unwelcome conduct based on an employee's membership in a protected class. There are some legal standards that have to be met in order for there to be a viable claim of harassment or discrimination. And there are minimum thresholds that courts require in order for the victim to have a viable lawsuit. And there is a line of acceptable behavior that must not be crossed in the workplace. In order for a employee to have a claim, that line of acceptable behavior has to be crossed. And as we dive into some of Colorado's new laws, you'll find out that that line has grown. There are broader protections available to employees, and so it's important that you're aware of that. The United States Supreme Court defines that a hostile work environment is created when the workplace is filled, that should say filled, not filed, with discriminatory intimidation, ridicule, and insult that is sufficiently severe or pervasive to alter the conditions of the victim's employment and create an abusive working environment. That's a lot of words in there. But they did that for a reason because so many different things could potentially be defined as harassment or discrimination. And we will talk about how that definition has sort of changed, not only with the state of Colorado, but also within the EEOC. So the EOC does define hostile work environment as unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature when this conduct explicitly or implicitly affects an individual's employment or unreasonably interferes with an individual's work performance or creating an intimidating, hostile, or offensive work environment. That's even more words, right? That's a lot of information in there to pack into it. And again, let's jump into the kind of how that changes over time. So, severe or pervasive is a huge sort of part of claims of discrimination and harassment. So, essentially, what the law is saying, what the courts are saying, is that there's a minimum threshold for discriminatory conduct must meet in order for the victim to have a viable lawsuit. That is generally viewed through this concept of severe or pervasive. The more severe the harassing conduct is, the less pervasive it has to be, and vice versa. So, severe meaning, intense, harsh conduct, pervasive meaning unwelcome and it maybe spreads throughout the organization. So, vice versa on what that means as far as how pervasive or severe it has to go. However, this was new just about a year ago. the EEOC in April of 2024 updated the guidance on severe and pervasive. And the EEOC has now said the conduct need not be both severe and pervasive, but the legal standard is severe or pervasive. So clear as mud, right? So essentially what they're saying there is that, again, the law says that it has to be severe and pervasive in order for it to meet the standard of hostile environment discrimination. However, cases are changing that. Cases are showing that it does not need to both be severe and pervasive. It could be more severe, could be less pervasive. It could be a one-time incident versus a multiple time incident. And now Colorado has changed that even more. So in a new law, Colorado Power Act was effective August 7th of 2023, so about a year and a half into this now. It has made changes to the Colorado Anti-Discrimination Act, or CODA. It stands for Protecting Opportunities and Workers' Rights Act. There are four big things that I think you need to be aware of. The very first one is that it discards the severe and pervasive standard altogether, and we'll dive into that. It limits an employer's affirmative defenses. It adds multiple conditions an employer must meet to enter into a non-disclosure agreement with an employee. And it updates record-keeping requirements when it comes to harassment and discrimination complaints. So severe or pervasive, again, this used to be the ultimate test. This used to be the ultimate standard by which, attorneys and employers viewed claims of harassment, and Colorado has changed that. And now it states, the Colorado Anti-Discrimination Act states that the conduct or communication need not be severe or pervasive to constitute a discriminatory or unfair practice. This was huge. This is really big for Colorado employers because it really kind of leaves that wide open. So then what does it mean to have discriminatory or unfair practice if it doesn't have to be severe? Does it mean that it could be a one-time incident that never happens again and it could be discrimination or harassment? Does it mean that it's a bit kind of a low-level issue that doesn't necessarily rise to the level of being severe? We kind of don't know. We're at this point of a lot of employers commented on this regulation before it went into act, and a lot of employers in Colorado had concern with due cause because it really broadens the definition for employers of what it means to have a hostile work environment. And I think we're still learning that from this. It'll be interesting to kind of see where the Colorado courts take this over the next few years to try to define this a little bit better. Part of this also is that there is always this threshold to meet a harassment claim, and Colorado has kind of changed that definition as well. So a couple of things about this are that submission to the conduct or communication is explicitly or implicitly made a term or condition of the individual's employment. And I should note that only one of these three items have to be met for an employee to make a claim of harassment. Second is submission to, objection to, or rejection of the conduct or communication is used as a basis for employment decisions affecting the individual. So I want to talk about the first two before we move to the second. So the first two really is more about this job status discrimination. It's that situation in which, a supervisor asks an employee to go on a date with them, the employer refuses, and they say, if you refuse, I'm not going to give you that promotion. If you refuse, I'm going to fire you. Or, it's kind of that very deliberate type of action, cause and effect that occurs. That's sort of what those first two bullet points are describing there. The third bullet point is more focused on that hostile work environment. So the conduct or communication has the purpose or effect of unreasonably interfering with the individual's work performance or creating an intimidating, hostile, or offensive work environment. And as we talked about, hostile work environment is the more common one because truly, I think that people have learned since the Title VII went into place in 1964 that you can't be so explicit about it. You can't have sort of this cause and effect of harassment, because that is going to get noticed even more. While all types of harassment and discrimination are bad, I think that people have just learned how to maybe change it up so that it doesn't have such explicit actions tied to it, so that it's not so visible to everybody. A couple of more things I want to point out about the Colorado Power Act before we move on are, so an affirmative defense means that an employer, even though, let's say, harassment has occurred, an employer is going to say, okay, so you find that harassment has occurred. However, we as the employer, we did all the right things. We had a solid policy into place. We did all the training we could. We promoted a culture of anti-harassment. We've done all those things. So that could potentially lessen the harm to the employer if a claim does come forward. The Colorado Power Act has changed some of those things about when an employer can use an affirmative defense, though. First and foremost, it is specific only to claims that the supervisor is the alleged harasser. If an employee is claiming peer-to-peer harassment or something else, Colorado Power Act now says that an employer cannot even use an affirmative defense at all unless it is specific to the supervisor being the harasser. Second part is that the employer has to have an established program that reasonably designed to prevent harassment, deter future harassment, and protect employees from harassment. The employer has communicated the existence and details of how to make complaints, and the employee has unreasonably failed to take advantage of this reporting program. So those couple of bullet points there in the middle are really that policy and procedure, again, making sure that you have a solid anti-harassment policy in place. You've disseminated that to employees. Hopefully employees have signed off on it. You've done training on it. And as part of that, you've said, here's how you can report harassment. And then you can use the affirmative defense if it meets all of those claims and the employee has unreasonably failed to take advantage of this reporting program. Meaning that maybe the employee went directly to the EEOC to file a claim instead of reporting it to the employer. Other protections under the Colorado Power Act that you should be aware of, there are more strict rules around what can be included in non-disclosure agreements. So I would encourage you to have an attorney review that if you have non-disclosure agreements with your employees right now, or if you're looking to do a non-disclosure agreement, maybe as part of a settlement compensation or something like that, have your attorney review that just to make sure that the language is appropriate for the new law. Other protections are marital status. Basically, it just says that you cannot be discriminated against based on your marital status, if you're married or single, which is kind of strange, but okay. And then the final thing to be aware of is that it does change record keeping laws when it comes to harassment and discrimination. All employers must now keep all records of harassment and discrimination claims and investigations for 5 years after the investigation. So be aware of that and make sure that you're keeping up to date on some of those changes for record keeping. So let's talk about conduct that is based on sex or sexual nature. So quid pro quo is sort of that blatant type of harassment and discrimination that I talked about that most people don't do anymore. In Latin, quid pro quo is Latin and it means this for that. And it involves expressed or implied demands for sexual favors in exchange for some benefit or to avoid detriment. Again, this is where, if you don't have sex with me, I'm your supervisor, I'm going to demote you, I'm going to fire you, you're not going to get that promotion, etc. Based on sex means that it's unlawful even if there is no conduct of an identifiable sexual nature. This can be things that are not so overtly sexual. It can be mannerisms. It can be communications. It can be, jokes, posters, pictures, a variety of different things that does not have to necessarily be identifiable from a sexual standpoint. And then we have conduct of a sexual nature that is unlawful even if it's not based on the victim's sex. It can be conduct that is harassing to an employee, regardless of whether you're male or female, whether they are male or female. And we're going to talk about a really important case that helped define that. What we have learned and what the laws have taught us is that the harasser's motivation is irrelevant. Point simple, it is unlawful to harass any employee on the basis of that employee's membership in any protected class, regardless of the harasser's motivation, regardless of why they say they do it, regardless of whether they're attracted to somebody or it's some other reason. That does not matter anymore. What it's generally defined as, though, is two different categories, as attraction or animus. So if there is attraction based on, or harassment based on attraction, the harasser is sexually attracted to the victim and exhibits that attraction in inappropriate ways. If it's animus, it's based on hostility towards members of the protected class or one particular member of a protected class. Again, could be harassing somebody because they're male, could be harassing somebody just because they're female, which, again, harassment or discrimination based on gender is illegal. Forms of harassment, it can take multiple different forms in the workplace, and it's unlawful regardless of the form it takes. But some things to be on the lookout for in your environment are physical harassment. And these would be things, maybe somebody's a hugger and maybe somebody doesn't like to be hugged. Maybe I used to work with somebody who always liked to feel people's fabrics, and somebody did not like that. So they would walk up to somebody and feel their shirt and stuff like that. But it could be more severe, such as horseplay or sexual assault or something like that in the workplace as well. Verbal harassment, something as what you call somebody, maybe if you're using derogatory names, you're telling inappropriate jokes, etc. Nonverbal harassment and gestures, something as simple as maybe you're quote unquote like mean mugging somebody you're mad at. Maybe you're making inappropriate sexual hand gestures to people or something to that effect. And then inappropriate visual displays, if people have inappropriate things up in their work environment. And this could include the home environment. So there are folks who are still working remotely, and it is still a requirement that you don't have inappropriate posters like behind you when you're on a Zoom call and things like that, that your work environment must still meet the requirements, whether you're in the office, or the requirements of your organization, whether you're in the office or working from home. So same-sex sexual harassment, this was, when you think about laws and the ways that it changed, it was from 1998, which is actually a fairly new law when you think about laws. But this case defined that victims of sexual harassment can either be male or female, this was really important and groundbreaking when you think about Title VII came out in 1964, and this case hit in 1998. It's called OnCal versus Sundowner Offshore Services, and there was an employee, his name is Joseph Jody OnCal. He went by Jody OnCal, and he worked for Sundowner Offshore Services, so a big oil rig out in the middle of the ocean, all male employees working there. And the male employees assaulted Jody OnCal in multiple different ways. They were physically assaulting him, verbally assaulting him for in a variety of different ways. This case established that male on male sexual harassment is actionable. So it was kind of groundbreaking again for 1998. It also defined that the victim and the harassers were all heterosexual. So this no longer meant that sexual attraction was the motivation for sexual harassment here. It changed that law from that perspective. And then again, so that the harassers were not motivated by sexual desire, they were motivated by animus. They were literally just abusing Jody OnCal because he was Jody OnCal. And it likely had occurred with others as well, sort of like a hazing sort of event when new people joined the company and things like that. But it was a groundbreaking case that has changed our laws forever going forward. Okay, let's touch back on just job status discrimination for a quick moment here to talk about this. Again, job status discrimination may happen with regard to hiring, firing, compensation, promotions, etc. This again could be something very specific and very cause and effect, very this for that. Again, you don't really see that happening too much this day and age. However, what I would encourage you to do is review your procedures, make sure that you are being equitable across the board in terms of male and female pay, decisions about promotions and who has what level of leadership and supervisor, and that you are evaluating processes to ensure that you're being equitable for both male and female, non-binary, transgender, etc. Some additional legal standards to be aware of and very important things that are involved in harassment claims are the objective subjective stance. So essentially, objectively offensive means that it is offensive to a person of the victim's same demographic. So sort of what the EEOC has done that like has evaluated cases on is like, for example, if the victim is a female, you would poll like 3 females of the same sort of demographic and determine, is this objectively offensive to them? Now there's the subjective part as well to say it must also be offensive to the actual victim. So the victim, somebody could report something, and then the alleged victim might say, yeah, but I wasn't offended by it. So maybe there's a joke being told at the office towards somebody, and somebody else reports it, but the victim's like, well, I didn't find it offensive, actually. I'm not offended by that. So it wouldn't necessarily meet the legal standard for harassment or discrimination. So third-party victims. So the victim does not actually have to be the person being harassed. So this kind of goes back to that, what I was just saying about the joke. So maybe there's a group of people standing around, and every day they meet up to tell, dirty jokes in the break room or whatever the case would be. And even there might be somebody who sits next to the break room who isn't involved in the conversation, but they are offended by the conduct that is occurring, even though it's not occurring directly to them. The third party victim can file a claim of harassment based upon that. Off-duty conduct that is off-duty can give rise to sexual harassment if the claim is connected to the workplace. This would be something specifically, I'm going to use an example that I had at a previous employer. There was a group of attorneys, this employer, they were employees of this organization, and they went on a conference up in the mountains somewhere. And so it was paid for by the employer. They were there representing the employer, and so then it became connected to the workplace. And so after hours, they decide to have some drinks. They decide to go hot tubbing. One person starts making inappropriate comments. People are offended. And so it was looked at as though, well, but they were not truly working at the time. However, it was evaluated in the fact that these group of people would not have been in that location, in that situation, if not for the employer. So they were sent there from a work perspective, so then it became a work issue. It was off-duty conduct that gave rise to sexual harassment. The difference would potentially be is if you had a group of employees who just decide after work one day, I'm going to go have some drinks, and then, oh, by the way, we're just going to go sit in this hot tub. It wouldn't necessarily give rise to a worker or a employer's sexual harassment claim because the employer wasn't sanctioning it. It wasn't something that the employer put together. So that could be the difference there with off-duty conduct. Documenting and reporting harassment. What we generally like to encourage is that obviously if bad behavior is occurring in the workplace, we want the person to be able to stand up, the alleged victim to be able to stand up and deal directly with the harasser and say, I'm not comfortable with that. I don't like how you address me. I don't like how you talk to me. Please don't touch me. Do those kind of things directly. That's not always the case because again, it's a pretty, could be a tense environment. They could be uncomfortable with the whole thing and don't feel like they can address the person directly. So then we do recommend that you have a procedure where they can report the incident to a supervisor or to like a human resources department, something where they can make their claims known in a safe way. It's important for not only you, but the employee to document these issues as they occur. We encourage employees to Write down situations, because you might be so intimidating or offended that you might kind of forget part of what occurred. Take photographs if somebody's leaving you a picture. Keep copies of texts or emails and things like that. The same thing for the employer when a claim is received by you or to you, is to make sure that you're documenting everything that was told to you. Ask employees to write a statement. Ask for all documentation. Ask for those emails. Ask for copies of the texts. Make sure you're talking to witnesses and getting their statements as well. And then keep that documentation, because now we know that Colorado law says you have to keep it for 5 years. And then, of course, to make it known that retaliation is prohibited by law, period. So when a situation occurs, it's important to inform all involved that if they make a claim of harassment, if they participate in an investigation of harassment, they are protected from being retaliated against, and that is protected by law. Not only should you have this as part of your company policy, but protected by law as well. So the external, if something can't be resolved internally, which usually sexual harassment complaints can be resolved internally. That's the hope. Gosh, if something is occurring, we want the employer to address it. We want to make sure that the behavior is stopped. However, it is important that employees have a couple of options for going externally to file a complaint, and they can do that through the Equal Employment Opportunity Commission. They do have to file their complaint within 300 days of the last incident of discrimination. So this behavior could have been occurring, for 2 years, but if the last issue occurred last week or within the last 300 days, they can go ahead and file a claim of discrimination. Employees can also go to the Colorado Civil Rights Division. They do have to file within 6 months of the harassment or discrimination. Most employees will go to the EEOC versus the CCRD. And I will say, generally, if the CCRD gets a complaint, they often bump it to the EEOC to handle. Usually the CCRD isn't staffed enough to handle the complaints, but employees do have the option to go there. Regardless of how you get, let's say you get a complaint from the EEOC indicating that employees filed a complaint of harassment or discrimination, they give you a certain time frame to respond. That's usually about 3 weeks to respond. And you can request an extension on that. They'll usually give you a couple of weeks extension. They're not going to give you, months or anything like that, but you can request an extension. And then when you file your response, the EEOC will make a determination. Regardless of the determination, whether the EEOC says that a harassment did occur or didn't occur, the employee is going to get something called a right to sue letter. This right to sue letter tells the employee that, again, regardless of the outcome, they have the opportunity to file a lawsuit. They do have to file that lawsuit within 90 days. So not a lot of time frame to do that in, but just so you know, regardless of the outcome, the employee will get a right to sue letter. This is just a little information of some EEOC charges. We should have more up-to-date charges out anytime soon. Takes a little bit for the EEOC to compile things, but these are in tens of thousands. So these are sexual harassment charges from 2014 to 2021. And so when you look at, so for example, in 2014, it says 6862, that's 68,000 charges that were filed. And so if you kind of go along, it's pretty consistent overall, but obviously there was a spike in 2018 that went up pretty significantly. Anybody know? And I'm going to ask you to put in the chat, do you know why it might have spiked in 2018 from 2017? Almost by quite a bit there, actually, as I'm looking. That it's really low. It's really small type. I need my glasses, but yeah, it spiked in 2017. Perfect. You guys are so smart. Yes, the Me Too movement occurred it came out in 2017. Yeah, you guys are great. So let's talk a little bit about the charges. This is just between 2018 and 2021. Total EEOC charges. This includes, race, religion, disability, etc. They received about 278,000 total charges. Of those charges, 98,411 were charges of harassment, and about 27,300 were charges of sexual harassment out of that. So just so kind of gives you an understanding of how many charges are coming into the EOC. And yes, in 2017, a very important movement happened called the Me Too movement. It was a social movement and awareness campaign against sexual abuse, sexual harassment, and rape culture. And it was mostly focused in sort of that Hollywood environment. However, it did spread vastly throughout other culture, other work environments and other companies and environments as well. A big part of that came out of Harvey Weinstein, who was a Hollywood producer director in October 17th, and multiple sexual abuse allegations came out against him. He was imprisoned, I believe is still in prison. And some of those charges, though, have been dropped against him. But there are still, I think, many that he was prosecuted for and found guilty of. Again, just a little bit about some EEOC charges. So the percent of sexual harassment charges filed by women from 2018 to 2021 are still showing that women are the main victims of sexual harassment. So 78% of sexual harassment charges were filed by women during that time. And then the percentage of all harassment charges from that same time is still overwhelmingly by women. 2.2% of all charges of all charges of harassment were filed by women during that time. I think one thing that's important to talk about that has become a part of sexual harassment and abuse in the workplace is bullying. So bullying has really, I think, even probably 10, 15 years ago, it really started to have this conversation socially, but also at work about bullying. And this can happen really in any environment. And it may include verbal abuse, threatening or intimidating verbal or physical conduct, sabotage, or undermining a person's work performance. Now, this bullying doesn't necessarily have to mean that it is sexual harassment, but where we're tying this into sexual harassment and discrimination is the fact that maybe it's happening from one gender to another. Maybe it's happening because somebody is transgender. Maybe it's happening because of somebody's gender identity or gender expression. And so this is something to be aware of, and something that I think it's important for companies to focus on is how they can quell bullying if it's occurring, how they can, prevent and stop abusive conduct in general. So things such as being rude or inappropriate at work, where you're not professional, where you have team members who are, just can't get along, that could potentially rise to the level of a sexual harassment complaint. Again, if somebody believes it's based on their gender, doesn't again have to be sexually motivated or doesn't have to include sexual content. It could just simply be that, oh, I'm a male, I'm a female, whatever the situation is, I think they're treating me this way because I am male or female. So it's important to make sure that you're evaluating conduct in your workplace overall. I would say it's important to make sure that you're educating your supervisors on what behaviors to be aware of, and that it really is the supervisor's responsibility to stop behaviors that are inappropriate. Because again, you don't know if it's just somebody being rude or somebody just can't get along with somebody else, but that it could rise to the level of what would be considered harassment or discrimination. So again, going back to make sure that you're putting in really solid policies against harassment. I would include bullying behavior. I would include language around that, and making sure that you're educating your employees on what is appropriate and inappropriate in the workplace. And some of you might be organizations that, like when I think of fire districts or, first responders and things like that, you're putting folks in positions where they're spending a lot of time with each other at work. They might have several days where they're on call, on duty, and spending time with other people. And sometimes behaviors tend to get really comfortable in those situations. But all it takes is one person to be offended. All it takes is one person to feel unsafe in that environment. So making sure that you're educating your employees on what is considered abusive conduct, but more importantly, what will not be tolerated in your work environment. If you do have a situation where you have a harasser, you've done an investigation, it's come down that somebody did treat somebody inappropriately. I will say that oftentimes I've been in HR for 33 years, and I don't even know how many investigations I've done of harassment. um, it's really hard to define that something was so specific that it would be sexual harassment or hostile work environment or whatever the case would be based on someone's sex or based on what is considered a legal protected class. Sometimes that's really hard because again, it's usually not so blatant. However, what you'd want to do if you have that situation come forward is make sure that there are consequences for the harasser. Make sure that the harasser knows that this behavior is not tolerated and that there are consequences that will occur. And that could be anything from, maybe the person needs to go to sexual harassment training. Maybe the person needs to do sensitivity training or something to that effect. Maybe they get written up. Maybe there's a discipline policy at your organization, but it could also lead to termination. I think that that's important, that you're evaluating the level of the situation and what is the appropriate consequences for the harasser. Again, hopefully your policies and sort of consistent behaviors throughout things that you might be reviewing of what has been tolerated or not tolerated in the past would be evaluated to determine what is the appropriate action to take against the harasser. But it is important, again, to remember that individual harassers can be named in lawsuits in Colorado, and that, again, oftentimes that doesn't occur. But if it does, sometimes it's the supervisor. I would say more often it's the supervisors or managers that are named because the employee is holding the supervisors and managers liable for the fact that they were treated with harassment or discrimination in the workplace. And that really comes down again to the fact that supervisors, managers, etc., are responsible for making sure that the work environment is appropriate and making sure that it follows the policies and procedures that you have in place. I think the bottom line to remember when it comes to harassment is that regardless, you should have respect for all employees in your workplace. This is something you should promote within your culture. Make sure that employees know that if they're not being respected, they should report that. You want to address that. You want to put a stop to it. It's important to know that federal and state laws protect all employees from harassment and discrimination. Again, might not even be an internal situation. It could be that you have a vendor or a customer or somebody coming in or contacting your employee that is harassing them. Treat people as individuals on the basis of factors that are relevant to the work environment. So, is it relevant that so-and-so is a female? Is it relevant that so-and-so is transgender or non-binary? It may not be relevant to the job at all. Treat them as an individual for what they bring to the job, their professional skills, their abilities, their, what they add to the environment from maybe job skills or their personality and things like that, versus don't make it about a protected class, age, race, gender, sex, etc. And that sexual harassment is broadly defined, and it is more broad with the addition of the Colorado Power Act of 2023. So I would, caution you to kind of keep that in mind as well. And again, it doesn't have to meet severe and pervasive, which was always for years what we looked at to determine what was sexual harassment and what the courts looked at, what attorneys looked at, et cetera. And that has changed. And we're going to, kind of keep an eye on Colorado cases as they go forward, because that's how we'll learn as to what is defined as harassment particularly, and what it means to not have to meet that severe and pervasive standard anymore. So Things are always changing. Really encourage you to keep up on new laws as they go forward. Like I said, it used to just be the EEOC and Title VII kind of ruled all, but now we're seeing much, much more that states are doing enhanced laws, and Colorado is certainly one of those states as well. So important to keep up on the changes within the Colorado law. And that is all that I have. Are there any questions? I wanted to leave some time in case there were any questions anybody might have. If you want to put that in the chat, I'm sort of happy to answer anything that you might have questions on. I know that sometimes it's hard to ask questions about sexual harassment, but be general. Don't use names and specifics to kind of help with that.
Thank you, Jennifer. And while people are typing those out, I did see a question earlier in the chat asking whether the slides would be available. On your screen, if you go up to the section that says files, it should be in your upper right corner. You'll see a little sexual harassment prevention thing that you can download. Those are the slides. And if you want to see this presentation all over again and hear Jennifer's beautiful voice, the recording will be sent out to meeting participants afterwards. So if there's anything that you're worried about missing, don't worry, we will be sending those out once the recording has processed. While people are typing out their questions a little bit, just to give a little bit of extra time, Jennifer, I've got a question for you. So It seems like you mentioned there's been a lot of updates to the legislation in the last couple of years alone. How much leeway have you seen for anyone that has, maybe not kept so up to date on the legislation? Like they do have a procedure, they are, trying to prevent harassment, but it's not quite up to par of some of the changes that have been made in the last couple of years.
I think that's a really good question because I think things are changing so quickly that it is hard to keep up. In my opinion, if the employer shows their intent to do the right thing, I know employers have policies, they haven't updated a handbook for 5 or 10 years. Totally understand. But as long as their intent is to make sure that they're doing the best thing they can to protect employees from harassment and discrimination, I think that's what matters most. So still having those policies in place, still making sure that you're training folks. I definitely recommend you have employees sign off on your policy so that you've got record that they've received it. It doesn't hurt to do a quick meeting about it, depending on, how many employees you have, just to say, hey, we do not tolerate harassment or discrimination of any kind. We highly encourage you to report if there are any concerns or things that come forward, because it is hard to kind of keep up. But I think if you can show that overall you have policies in place saying harassment and discrimination are not okay, you're doing the best that you can probably do and doing the right thing if those employees come forward and bring a complaint or concern overall.
Okay, thank you very much. It looks like we've got a couple questions in the chat, so I will let you go through those at your convenience.
Sure. So we have a question about how do you address right away political talk against a protected class, LGBTQ, etc. I think it's one of those, it can be I understand why employees want to do that. I understand why they want to support that and whatnot. Overall, I would say anything related to a sexual, anything sexual, even so LGBTQ, et cetera, doesn't necessarily mean sexual, but if it could lead into gender expression, gender identity, it could also lead into conversation that does make people uncomfortable. And that would be where I would go with it, is to say, this is not conversation that's appropriate for the workplace. Certainly you need to focus on your job and doing, what you need to do. It could also be a situation where, might have to remind people that maybe people from the outside walk up to a desk. I'm not sure what the situation is, but maybe if it's like a front reception desk and they're having this conversation, people from the outside might be coming in as well. And so you want to make sure to keep your conversation focused on appropriate work topics. That might be one way to address it. It could be something that you don't want to have the conversation be where we're not ever going to talk about LGBTQ. Instead, say we need to focus our conversation on work topics and work appropriate talk. And so that would be something that wouldn't be discussed during this time. That's probably how I would address the situation, just to make sure that, again, if employees might feel uncomfortable or other people might feel uncomfortable, just in general, it probably shouldn't be talked about at work. That kind of goes back to that old adage, you shouldn't talk about sex, religion, or politics at work in general. And I still feel like that might be a good adage to live by these days. So. Another question, is foul language talk about sex considered sexual harassment? It absolutely can be. Again, it might not be offensive to one person, but it could be offensive to the other person. It could be offensive to somebody sitting nearby, and might not even be involved in the conversation. It goes back to, again, what is appropriate conversation for the workplace, and making sure that you're promoting a safe environment where employees feel like they're not subjected to foul language or talk about sex. So yeah, it definitely could be considered sexual harassment. Another question, are there any requirements for ongoing harassment awareness training for employees? Colorado doesn't specify that right now. However, I do see that going forward. My recommendation is generally every 2 years, unless you're turning over folks quite regularly. You might want to make sure that it's a yearly training. If nothing else, I would say make sure that you're even sending out your policy on anti-harassment yearly to employees. It doesn't hurt at all just to take a few minutes and say, hey, we just want to reiterate, our culture is anti-harassment, anti-discrimination. We don't tolerate these things. Something as simple as that, and even just document that you sent that out to employees, would be helpful. But truly, training even for supervisors from a every other year perspective at the minimum is what I would recommend. I would say, again, yearly, if you feel like you have more turnover or have some new folks that maybe need some refreshing with that.
All right. It looks like we haven't had too many other questions pop up. And since we're coming up on the end of the hour, Jennifer, thank you so much for your time today. And thank you for everyone who attended. In case you're interested in learning a little bit more about CPS HR, our partnership with them, or what you can do to acquire their services, I will also say that CSC pool members are eligible for up to 10 free hours of consulting, and then after that, offered at discounted rates. I've put the link to that in the chat. And then if you miss it here, you're more than welcome to email and ask any follow-up questions. Once again, Jennifer, thank you so much. Thank you all for your time. And I hope you all have a good day.
Thank you very much.